The court held that the First Amendment prevents Colorado from forcing Lorie to say a government message that she doesn't believe, and that the government cannot misuse the law to eliminate ideas it dislikes from the public square. The Supreme Court agreed that Lorie works with everyone, including those who identify as LGBT, and her decisions to create speech always turn on what the message is, not who requests it. Lorie is now free to speak and to create consistent with the core of who she is. This is a landmark victory for all Americans, regardless of one's beliefs. As the court today noted, it has long held that the opportunity to think for ourselves and to express those thoughts freely is among our most cherished liberties and part of what keeps our republic strong. The First Amendment's promise of free speech extends to everyone on all sides of any debate. The government should no more force Lorie to speak against her beliefs about marriage than an LGBT website designer to speak contrary to her beliefs. Neither should a Muslim cake artist be forced to create a custom cake with a message criticizing Islam. A pro-abortion filmmaker should not have to make a documentary that advances or promotes the pro-life movement. And a Democratic speechwriter certainly shouldn't have to write a speech promoting a Republican candidate. The same principle also applies to ADF's other clients, such as Jack Phillips, Emily Carpenter, Chelsea Nelson, and Bob Updegrove. These cases are pending in the courts of appeals right now across the country. Today's decision ensures that no government official can punish an American with jail time, six-figure penalties, and any other penalties for speaking consistent with their beliefs. Today's decision affirmed that states like Colorado cannot eliminate beliefs they dislike from the public square. People like Lorie, who believe that marriage is a unique relationship between a husband and a wife, should not be bullied, persecuted, or banished from the public square for peacefully living and speaking out that belief. A belief that is held by millions of people from all walks of life, all races, diverse faith traditions, and no faith at all. Even people who reject Lorie's beliefs about marriage should stand with her, because they too might be the ones who face censorship when political or cultural winds shift. The court's rejection of government censorship protects and promotes pluralism, a society where all Americans are welcome to engage in public life and can say what they believe, even if their beliefs are disfavored by their government. As the court held today, the freedom to think and speak is among our inalienable human rights. By allowing all views to flourish, the framers understood we may test and improve our own thinking, both as individuals and as a nation. You may hear attempts today to misconstrue this important victory for all Americans in the days ahead as well. So let me be very clear. Public accommodation laws have coexisted with First Amendment rights for years. Government officials have never needed to compel speech to ensure people are not denied access to goods and services. But it's been in recent years that government officials have sought to misuse these laws, stretching them beyond recognition. And in doing so, they're censoring speech they dislike by falsely labeling it as discrimination. But the government can't label speech as discrimination in order to censor it. The court's decision means that states will ensure no one is forced to say something that they don't believe, while also ensuring that no one is denied goods and services. America's commitment to free speech has enabled some of our most significant social progress, from abolishing slavery to advancing women's rights to vote, to even passing the 1964 Civil Rights Act. Those movements flourished because our nation absolutely refused to silence or coerce people. Without the freedom to speak, we shutter diverse views, shut down meaningful debate, and we stop the conditions that are required for progress. Today's decision affirmed these important principles, and the court expressly said, tolerance, not coercion, is our nation's answer. The First Amendment envisions the United States as a rich and complex place where all persons are free to speak and to think as they wish, not as the government demands. So I hope that everyone celebrates today's decision because it upholds a fundamental right to say what you believe without fear of government punishment. And that's a win for all of us. Thank you.
Thank you so much, Kristen. Next, we'll hear from the owner of 303 Creative, Lorie Smith. Lorie, the floor is yours.
Well, good morning. My name is Lorie Smith, and I'm a graphic and website designer. I own 303 Creative in Denver, Colorado. Today, I am incredibly grateful for the U.S. Supreme Court's ruling today that says that I'm free to create custom designs consistent with my beliefs without the fear of Colorado punishing me. This is a victory not just for me, but for all of us. Whether you share my beliefs or completely disagree with them, free speech is for everyone. The government should not force anyone to say something we don't believe. And the court's decision means that we are all more free today than we were yesterday. We can think, create, imagine, and speak consistent with the core of who we are. Years ago, I left the corporate design world to start my own art studio because I wanted to promote causes that are close to my heart. I love creating custom artwork for overseas missions, homeless ministries, animal rescue shelters, and organizations for veterans who have selflessly sacrificed to defend our country. I love people, and I create custom artwork for everyone, including those who identify as LGBT. For me, it's never about the who, it's about the what. When considering a potential project, I always look at the message being requested, never the person requesting it. My canvas is on paper, sometimes pixels, and I cherish the freedom to craft messages and celebrate things that I'm passionate about. I was excited to expand my portfolio to design custom wedding websites celebrating marriage between a husband and a wife. But the state of Colorado told me that I couldn't speak consistent with my beliefs, and I had to create custom artwork that conflicts with the core of who I am. Colorado wanted to punish me for my speech, even though it agreed that I, like most artists, always choose my projects based on the message, never the person requesting the message. So I stood for freedom, and I challenged Colorado's injustice. It has been a long and difficult 7-year journey, one where I've had to face harassment, constant hacking attempts, and even death threats. But the Supreme Court's ruling today corrects that injustice. Excuse me. I'm so very grateful to the United States Supreme Court, who affirmed today that Colorado can't force me or anyone to say something we don't believe. This is a victory for all Americans across our great country, whether you share my beliefs or hold different beliefs, whether you're an LGBT graphic designer, a Jewish calligrapher, a Democrat speechwriter, or a pro-life photographer. The government shouldn't force anyone to say something they don't believe. I know that if we want freedom for ourselves, we must defend it for others. This belief and my faith have inspired me to persevere over these last several years. We will not always agree with one another, and that's okay. But civility and respect for one another is necessary for a peaceful society. Today, I sincerely hope, regardless of what people think of me or my beliefs, that all Americans will rejoice that the court upheld the right to speak freely for all of us. Thank you.
Thank you, Lorie, and thanks again, Kristen. We will now begin a period of moderated Q&A. I'm going to open up the floor in a second. I'll remind you that if you do have a question, unmute yourself. If you're calling in on the phone, you can unmute yourself by pressing *6. The one thing that I would ask is that you identify yourself by your name and by your affiliation. At this time, we will open up the floor.
Can we just start?
Yes.
Okay, I'm attorney Jessica Crawford with Denver 7 News. First question is for the attorney. What's your response to accusations that the 2016 inquiry from Stewart was falsified?
Well, it's not only wrong, but it's irrelevant. First and foremost, Lorie received a website request, design request from a third party. Even Colorado agreed. It's not her responsibility, nor is she able to do background checks on those who she's receiving these requests from, because Colorado has told her that if she declines in any way a request like this, she puts herself in the crosshairs of this law. So again, it's undisputed that the request was received. It was received by a third party, whether that was a troll and not a genuine request, or it was someone who was looking for that is really irrelevant to the case as well. She's received many other requests, but more importantly, Lorie filed a pre-enforcement challenge. And what the case law says and the Constitution allows is that people don't have to wait for the government to punish them to ask the court to declare that a law is unjust. And Colorado has been one of the most aggressive states in the nation to pursue and punish people who share Lorie's views. So again, it's not only a false statement and a mischaracterization and absolutely untrue what the New Republic reported, but it is also irrelevant to the case.
Thank you. Another question I have is, what is your response to concerns that this ruling could lead to business owners discriminating against potential customers at a higher rate than what they used to, and in a way that could be compared to segregation?
Americans should read the decision, and what they'll find that decision says is that non-discrimination principles and public accommodation laws have peacefully coexisted with the First Amendment for years and will continue to do so. Those non-discrimination principles still apply so that no one is denied access to goods and services, but everyone has the right to free speech. And that's a win no matter what side of a debate you're on. It's a win for the LGBT website designer, the Democrat speechwriter, as well as the Muslim artist. It protects all of us.
Hi, this is Colleen Slevin. I had another question about that request from Stewart. It looks like from the court filings that was a request made through Lorie's website. Is that what you mean by a third party?
There's a form on Lorie's website where people can request services, and that request was made by a third party to Lorie's website. But again, I think what's important here is that it's irrelevant to the legal analysis. Lorie has received many other requests, but those requests aren't even required for her to have the court adjudicate this case on her behalf. She's waited 7 years, and for that 7-year period, Colorado has aggressively argued in court that she would break the law and subject herself to punishment if she declined to create a custom same-sex wedding website. So again, the issue is not only irrelevant, but these contentions are absolutely false.
So you're saying Stewart is lying when he's saying he didn't make that request?
I'm saying that there are a lot of trolls out there and that we represent different clients in these areas. And Justice Jack Phillips has received a number of, I would say, ungenuine requests. It may be that Lorie received one too that lacks sincerity or that was a setup. We don't know that, but it's irrelevant to the legal analysis. What we do know, and that Colorado itself has even agreed, is that she has received requests and that this was one of those requests, but that a request isn't even needed for the court to decide this issue, because no one should have to face fines or jail time when they're facing an unjust law like this. And thankfully, the court recognized it did violate the Constitution.
So your organization did not fabricate that request?
I don't know how many times
sure.
I have to say this. Absolutely not. And it's reprehensible and disgusting that that allegation would be made towards us. To suggest that in some way we did not honor the ethical implications, especially when even our opponents agree and have stipulated that request came in through Lorie's website. It's just unfortunate that we live in a culture where people would try to set up and force people to face punishment and force them to go to court just to be able to speak freely. That's the real injustice here.
Thank you.
My name is John Wester-Reed with the Standing Freedom Center at Liberty University. Am I here? Hello?
Yes, we can hear you.
Yes.
Well, Kristen, Lorie, it's good to see you both again. We're celebrating with you. We're celebrating this victory with you. Kristen, thank you so much for spearheading not just the initiative with Lorie, but with Jack and with so many that you and your organization have defended. Lorie, thanks for your example as well. There are a lot of people who are unfortunately in your shoes, and so it's really good for them to see the example that you've set. So thank you for that. Kristen, my first question is for you. The question that the court agreed to review last year was whether the application of accommodation laws to compel or restrict speech violated the First Amendment. The question did not have anything specifically about Colorado or about any specific case. So my question is about the precedent here. Is this only for Colorado, or is this going to affect accommodation laws in states like New York for Emily Carpenter and others?
This affects every state that has a law like this, and every state that would have rogue government officials that are trying to misinterpret their laws and force people to say things that they don't believe. And it's important to point out, as the court did, that these principles don't just apply to one side of a debate, they apply to all sides. And that's what allows us to keep the republic strong and to engage in testing ideas and determine what truth is and making social progress. So it's a broad ruling. We're thrilled with the ruling, and we expect that it will help those who are caught in the crosshairs of government officials that are seeking to use raw power to force individuals to embrace ideas that they disagree with, including Emily Carpenter, including Jack Phillips, including Chelsea Nelson, and including Bob Updegrove. We are looking forward to seeing the lower courts apply this decision as the court will require them to do.
Okay, so just to follow up, and this is my final question. You said you hope the lower courts rule in favor. So the cases are not dismissed. They'll still move forward, but they'll move forward with this as a new precedent. Is that correct?
Many of the cases that are pending right now are awaiting for supplemental briefing on how this ruling would apply in their particular instance. And the court issued a broad ruling today affirming the principle that if you were creating expressive content, the government can't force you to create that content in violation of what you believe. It can't force you to say something that you don't believe. And so that legal principle will apply in all of those cases because they all are speech creators.
All right. Thank you, Kristen. Thank you, Lorie.
Thank you.
Another question for Lorie. Last time we spoke, you said you were interested in offering wedding websites and that, that the current laws prevented you from doing so. So what's your plan next? Are you going to start offering websites? And also, do you plan to post any messages on your website indicating work that you will and won't do?
Well, I'll tell you that I've been waiting for this moment for 7 years, 7 long years. Wedding seasons have come and gone in those 7 years, and I am looking forward to creating consistent with what I believe and what my faith teaches me about marriage. So yes, I am excited about taking this next step. And I'm grateful for today, for the victory. No one should be forced to say something they don't agree with. So today is a victory for all of us. And I think perhaps my attorney can speak to the second part of your question.
Was there
The statement?
The statement?
Yes.
Oh,
If she's
okay,
going to
sorry.
post a statement to her, if she posts a statement to her website saying work that she will or won't do.
Sure. Lorie has a statement that she has already prepared that's in the stipulations that Colorado agreed to in terms of that would describe what her beliefs are on a variety of issues and how she makes her decisions based on what the message is and not who the person is. We'll be looking at that in light of the court's decision today. And she may want to change that a little bit. I don't know. She needs to take a fresh look at it. As I said, it's been 7 long years of waiting to be able to even enter into this industry and then to post a statement. So might have a few tweaks to it. I don't know as time has passed, but it's certainly something she'll be putting up in due time.
Okay. And just to confirm, you will be offering wedding websites now after this?
Yes, that's what I wanted from day one.
Okay, thank you.
This is Mark Kellner. Question concerning the Emily Carpenter case in New York specifically. I know you said, Kristen, that this is a national ruling and applies across every state, but specifically, how do you see this shaking out in New York, where the Attorney General has already tweeted her opposition to the Supreme Court ruling today?
Well, thankfully, whether an attorney general opposes freedom or not, the U.S. Supreme Court ruling governs what that attorney general does. And we've seen that in Colorado now over the last 10 years. So the court has spoken. It has affirmed time-honored, time-tested principles that the First Amendment applies to everyone, including those who might disagree with her, including an attorney general who may disagree with someone's viewpoint on marriage. I also think it's important to point out, and also consistent with the last question that I had, that in the services that Lorie provides, all of the websites that she creates are custom. They're tailored to the couple, as the decision found today. So in every instance, she's looking at what the message is, not who's requesting it. So in that sense, she's not able to post any type of sign that would suggest she's categorically denying any type of service, because she doesn't do that. She serves everyone, including those who identify as LGBT. But she does look at messages, and she'll make her distinctions in what she creates based on whether it's consistent with her beliefs. And every artist has that freedom.
Okay, thank you.
Hi, I'm Lourdes Hurtado with Telemundo Network. In her dissent, Justice Sonia Sotomayor said that the immediate and symbolic effect of the decision is to mark gays and lesbians for second-class status. Lorie, as a Christian, what do you respond to this dissent?
I have always loved working with everyone. I serve people from all walks of life. I have clients who identify as LGBT. My case is about speech, and when speech is concerned, speech should be protected. Today's victory protects not just me, but protects the LGBT website designer. Everyone should be free to create consistent with what he or she believes. And whether your views on marriage are similar to mine or perhaps different, nobody should be forced to create a message that goes against his or her convictions.
I think it's also important to point out from a legal perspective that as the 6-justice majority explained, Justice Sotomayor's dissent was truly litigating a case that wasn't before the court. The facts are agreed in this case to what Lorie just said, and that she serves everyone. And truly loving our neighbor means ensuring that they have the same freedoms that we all have. And that's what this decision was about today. It does protect those who identify as LGBT or any other political or cultural persuasion to be able to articulate, advocate, and express ideas that are consistent with what they believe. And it comes down to, is it the government's role to tell us what to think and what we believe? It doesn't mean that the marketplace can't respond to it. What it does mean is that the government doesn't have the power to do that to the individual American.
Thank you.
One last question from me for Lorie. It looked like you got kind of emotional as you were speaking earlier. What's driving that emotion, and what is this morning like for you after learning of the court's decision?
What's driving the emotion is 7 intense years on this journey, walking through death threats, my home address being posted on the internet, threats of bodily harm, my family being threatened, all because I decided to stand and challenge Colorado's injustice because they were compelling my speech. And it has been a journey, but today is a victorious day. I'm so grateful. I'm grateful that the court has upheld that the government cannot force anyone to say something it doesn't believe. Today is a day of victory, not just for me, but for all of us. And I'm hopeful that everyone can see that no matter what you believe on the topic of marriage, that speech is worthy of protecting.
Thank you.
Hey, Kristen, this is Alex Sawyer with the Washington Times.
Hi, Alex.
Hey, thanks. I just had a quick question. I know obviously you're here with Lorie, but I didn't know if you wanted to speak to or comment on your other client, Jack Phillips, and in terms of what this ruling in Lorie's favor means for him.
Well, we're thrilled on Jack's behalf because I think that it means that this harassment and targeting that he's endured for 11 years now is finally going to come to an end. The rule, again, that the court articulated in its decision is that if you are expressing something, if you're creating expressive content, then your speech is protected. The government can't compel it. And it's not that all cakes are expressive content, but certainly Jack, it has been asked to create cakes that do have expressive content, that are expressing either his beliefs about weddings and the inherent expressive nature of those custom wedding cakes that he's designing, or right now he's being sued because he's declined to create a cake celebrating a gender transition that has that message of blue icing on the outside and pink on the inside to celebrate that transition. So we believe this decision protects Jack, but again, that core rule and the first question in all of these cases is there expressive content that is being compelled? And in Jack's case, that's certainly true, but that doesn't mean it's the case in all cake artists necessarily.
Okay, thank you.
Joe Mueller with the Center Square. I noticed that the opinion quoted case law, the Boy Scouts of America versus Dale many years ago. I believe it was 1998. And now looking back at that ruling, all the money, all the time that the Boy Scouts invested in that, and now they have changed and their rules have changed to more or less reflect society. To both of you, will we look back on this day and see it as a victory for the First Amendment, and yet know that the marketplace will probably, hopefully, be the driver instead of government?
Well, I think first of all, the decision included many, many cases, and you're just picking one of the many cases that the decision cited for the time-honored principle that when you're asked to create speech, the government can't affect your message. The government can't hijack that speech and force you to say something that you don't believe. That's the legal principle in that case. And I think the beauty of the First Amendment is, as you say, what someone expresses and what's considered popular may change through the course of time. As they say, today's orthodoxies may be tomorrow's heresies. And that is certainly true in our culture. But what is also true is that it's not up to the government to decide what those heresies are. It's not up to the government to tell Americans what to think and what to say. And that's the legal principle that I think we will be rejoicing over for generations to come, and that we have looked to in the past to see it has been applied appropriately and made our republic so strong.
We have time for 2 more questions.
Hi, this is Colleen Slevin from AP again. I did hearing about the Jack Phillips case. I'm just wondering, like, procedurally, what will happen next? Because I believe that case is still pending. His appeal is still pending before the Colorado Appeals Court. So do you have to take any action to ask them to look at this decision?
Absolutely. All of the cases that are pending will be submitting supplemental briefing. In some cases, the courts have already anticipated that and ordered us to file that supplemental briefing even prior to the decision coming down today. In Jack Phillips' particular case, there's a petition for review at the Colorado Supreme Court right now, and I would expect that we will file a supplemental brief very soon. And my hope is that the court will accept review and reverse the decision consistent with the U.S. Supreme Court's decision. And if it doesn't, we will continue to appeal that case right back up to the United States Supreme Court to ensure that all people can continue to speak freely when they're creating expressive content like Jack does.
Do we have a final question?
Yeah, Katie Eastman here with 9 News. I have a question. This might be for the attorney. You talk about how this is a win for everybody, for even for people who identify as LGBTQ, but we know that Alliance for Defending Freedom, most of these, so many current lawsuits are about people in the LGBTQ community, and the general consensus is that it's about taking away freedoms from people in the LGBTQ community. So how would you respond to that, but when you're saying that this lawsuit is about everybody's freedoms?
Again, I would encourage all Americans to read the decision rather than to read mischaracterizations of what the case is about. This is about whether all Americans have the right to speak freely, and that's a right that those who identify as LGBT, those who identify as Democrat or Republican or Libertarian, no matter what your persuasion is, what your faith is, you have the right to be able to speak freely. And it's whether the government can use its power to punish and even jail you for declining to speak a message that violates your convictions, regardless of what those convictions are. So I think, again, it's a win for everyone. And what's critical about this case is that the speech in the case and the fact that Colorado is seeking to compel that speech, to coerce someone to betray their convictions. The court said that that violates the Constitution. And again, that applies to all of us because we know that political and cultural winds shift. And if we want freedom for ourselves, we also need to extend it to those we disagree with.